My name is Renato Nazzini. I am a professor of competition law at King's College London. Today at the competition committee at the OECD we discussed legal professional privilege, and I made a few suggestions as to how we can reach some international consensus, or at least move towards some international standards in this area. Essentially, I made 4 points. So my suggestions are in 4 points. First of all, I think it's important that we understand what law applies to legal professional privilege, and I believe there can be 2 approaches. The lex fori, the law of a given jurisdiction, may apply, and that's absolutely fine. That's the approach that, for example, the European Union adopts. Equally, there can be a conflict of laws approach to that. So a country, a jurisdiction may decide to apply the law with the closest connection with the instructions. However, whichever approach you adopt, I think there should be a necessary but also a sufficient condition for privilege to apply, that the legal advisor is a lawyer registered under the bar rules, the professional rules of his own jurisdiction. I don't think the lex fori, the law of the jurisdiction where the proceedings are underway, should take away, strip, as it were, a lawyer of his professional capacity. So that should apply to in-house counsel, if they are still a member of the bar, members of the bar and entitled to practice, as well as to government lawyers under a given jurisdiction, seconded private practice lawyers who may be working with the client temporarily as in-house lawyers, and so on. Third point, however, is that even if lex fori applies, the law of a given jurisdiction applies, if legal advice or communications between a legal advisor and his clients are privileged under some foreign law, then it is absolutely not only sensible, but I think it may be required under fair trial standards to defer to that jurisdiction. Especially, for example, if the issue was an issue of purely domestic law, and the client had a legitimate expectation that the legal advice would be protected. On the other hand, and finally, I think the scope of the privilege is legitimately determined, could be legitimately determined under the lex fori. I do recognize these are ambitious proposals. It will not be easy to get there, but I think it's important to start work on international convergence in this area. That's fundamental for companies that work across jurisdictions, but actually it's also very important for competition authorities, because some common standards in this area, as well as many other areas, will facilitate cooperation in international enforcement, and therefore will be good for the effective enforcement of competition law as well.